I'm going to take exactly 30 seconds, and I'm going to invite the author of this book, which has been published by Taxsutra in conjunction with Oakbridge just a fortnight ago. This book is Royalty and FTS, authored by Mr. Sanjay Kumar, Mr. SP Singh, Mr. Sharad Goel. Sanjay ji, please, can I please request you to come forward and present a copy of the book to one of the foremost tax advisors, Mr. P.V. Srinivasan, former Wipro tax head and a member of the ATRAF. Sanjay ji, please. Yeah, this book, Royalty and FTS, discusses the business and tax interplay on this subject, and it aims to emphasize on the increasing significance of royalty and FTS payments for businesses, the reasons for intangibles gaining importance. It delves into the process and mechanism of how the valuation should be accurately done. Two things that stand out in this book. A, it's an in-depth analysis of 92 royalty agreements between unrelated parties and the impact on businesses, and an exhaustive coverage of natural resource royalty. Sanjay ji is a tax partner with Deloitte India, he's a public policy leader for Deloitte India and Deloitte Asia Pacific. Before that, he was in the IRS for 28 years, brings a wealth of experience with him on this subject. It's an amazing book. This has been one of our best sellers in the last 4 weeks. So if you've still not grabbed a copy, you can order it right here. Sanjay ji, please present it to people. Can we have just 1 second? 1 second. Can I invite my colleague Tanaya is here? Yeah. I hand it over to Tanaya. Thanks once again, Sanjay ji. Thank you. Yeah, please, sir. Please. While you organize the next one. Yeah.
I told Mr. SP Singh that I'll buy this book. I did not expect that I'll get a complimentary one. But there's one more good reason to buy this book now. Earlier, businesses accepted 10% tax out of abundant caution. Now the tax is 20%. You have to really interpret it as royalty or FTS. Please buy that book for that reason.
We are now ready to kickstart our next power-packed panel discussion on the subject of beneficial ownership in international taxation, evolving trends. In this panel discussion, our esteemed panelists shall trace the origins of the concept of beneficial ownership and the implications of its conspicuous absence in the capital gains provision in juxtaposition to the other provisions like dividend, interest, and royalty where it is explicitly present. The recent rulings on this issue have favored the taxpayers, but the last word is yet to be said on the subject, which makes this panel discussion all the more alluring. With no further ado, I would like to invite our moderator for the session, Mr. Nabin Ballodia from BDO India, to the dais. I would also like to invite our esteemed panelists, Mr. Kamlesh Varshney, Joint Secretary, TPL I, Ministry of Finance. Mr. Dali Buzora, President, Tax Research and Planning, Orbitax. Ms. Divya Gupta, Vice President, International Tax and Corporate Services, Interglobe Enterprises. Mr. Ajay Agarwal, Group Chief Financial Officer, Vedanta. And Mr. Aakash Uppal from BDO India. A brief introduction of our moderator. Nabin is a partner and leader for tax and regulatory services practice for the North region of BDO. He operates out of the New Delhi office and has over 25 years of experience in assisting clients on various facets of tax and regulatory matters, including inbound and outbound investment structuring, tax litigation, exchange control matters, and advisory matters. He is a chartered accountant, cost accountant, company secretary, and a Bachelor of Law graduate. He has worked extensively for clients in the energy and natural resources sector, as well as education and not-for-profit sector. He has also worked extensively on complex issues involving Foreign Contribution Regulations Act, as well as other tax laws. I would now like to hand it over to our moderator to kickstart the session for today.
Thank you. Thank you very much. So again, a good morning to all of you. For the last 1.5 days, We have heard about various concepts in international taxation. Some of the speakers have alluded to the concept of beneficial ownership. And this is the topic that we are going to talk about in far more details today. Just to give you a bit of a context about this entire, the concept of beneficial ownership, this is actually an anti-abuse concept which is used in the tax treaties primarily for the purpose of, or for the clauses that are for passive income. So clauses like royalty, fee for technical services, dividend, interest. So these are the clauses where this particular concept resides. If you were just to look at or track the history of it, the first time the concept was actually looked at in the US-Canada Treaty way back in 1942. But in 1977, this was actually included in the OECD model commentary as well. So that's the longevity of this particular concept, and it has continued all this while. Subsequently, even the UN models and the US models adopted it. But interestingly, none of these models actually define the term beneficial ownership, which actually allow courts to actually interpret it in the way they want it. So various countries, be it some rulings in Denmark, ruling in France, some of the rulings in India as well, have talked about this concept in a very, very different manner. They have interpreted it in a very different manner, and they have actually taken different positions. Some situations they talk about a pass-through, income. Some situations they have talked about the control and management. In some situations they have talked about, the timing of it. So all these things have been interpreted in different rulings, different ways, different times for the last, say, 40 odd years or so. And with the coming in of the BEPS action plan and the MLI and the PPT test that we talk about, there's a new dimension to the entire concept now. And that's the reason why we thought it would be good to actually deep dive into it and have a discussion on this particular topic slightly more in detail. Now, today we actually have a very, learned panel here. So we have Mr. Varshney is going to have, give us perspective from the government's perspective. Ajay and Divya are going to talk about the industry. Dali is going to give us international tax perspective as he's based out of Hungary, have worked extensively in the Netherlands also. And then we also have our own Aakash Uppal, who has done a lot of these, looked at some of these transactions very, very closely and advised clients on how to interpret the term beneficial ownership. Maybe to just get started off, maybe Dali, I'll start with you, straight away. So if you look at the way the rulings have been, various courts have taken different views, be it the Canadian, High Court in the case of Prevost ruling, or the Velcro ruling, or even the, MIL ruling, or the French judgments that are coming in. There's a lot of uncertainty about the entire concept. Everyone is taking their own views. And to that extent, it creates a bit of I would say, a haze around the entire concept. So, and the fact that it has been there for more than 45 years, it slightly confuses us. So why do you think that there's so much of uncertainty around the concept and the way it is to be interpreted?
Yeah, can you hear me? All right. Yeah, thank you. I think the uncertainty is really inherent in the concept itself of beneficial ownership and in its grounding in its history, its evolution. As you say, it is really a vintage issue. We are in 2023 still discussing it. Anyone born before 1971? No, after 1971 in the room? If I look at like this, I think most of the people basically born after 1971. The main judicial case in international tax law on this issue, the Aiken Industries, is from 1971, right? And we're still discussing it. I think it's due to a couple of reasons. One reason is the nature of the concept itself. Does it have an autonomous meaning within tax treaties? Is it the domestic law meaning? Now we have, for example, the European Union in what we call the Danish cases opined that it actually also have European Union law meaning, all right? If it does have a domestic law meaning, then do we follow the normal interpretation of tax treaties and follow that domestic law interpretation of the domestic law meaning? If you look, for example, Kenya, for example, it has in its laws something now saying that, which is linked to beneficial ownership, saying that treaty benefits would not be granted if the recipient resident in the other contracting state is held for 50% of more or more by a resident of a third country, because then they assume that it is just an interposition to use improperly the treaty that's being claimed, right? There are also normally, let me give you another reason as well, and that is the interaction between this concept and other either specific or general anti-avoidance concepts, whether in tax treaties or in domestic law. Another problem comes from confusion from the use of this concept in various areas of law. So, for example, the same concept is being used in what we now call ultimate beneficial owner registers, right? Is it the same concept? No, but it's confusing. It is used in anti-money laundering and anti-terrorism financing laws. Is it the same concept? No, but it's the same wording, right? If we go to the concept itself, basically, what is it about? It's about the interposition of an entity, that's the apparent immediate recipient, to take improper benefit from a convention or benefit under that convention that was actually meant not for him, right? So you interpose somebody to improperly gain a benefit, all right? For that, and there is a very recent, I think it's just 1 month old, decision by the Italian Supreme Court, which gives us the criteria of when does this happen, right? And there are 2 main criteria. The first criterion is simple, substantial economic activity, right? So if you have a substantive economic activity, that is more an indication that there is no really abuse meant or planned, right? That in itself is subject to interpretation. Sure. What is needed in the way of actual substantive activities to pass this test, right? The second criterion, which is very, very important, is dominion over the income, meaning free disposition over the income, right? An intermediary who is put in the structure normally does not have any dominion over that income. It just pass through. You pass the income to me, I pass it to her, right? Now, when does that happen, right? Normally what you look at the time lapse, for example, between me receiving the income from you and me passing on to her. If I pass on that income within, let's say, 24 hours, a month, whatever, then it is indicative of pass-through. What if I keep it for 6 months?
Yeah, so I think there's a lot of subjectivity which is there. So I think that makes it, so that's it. Then, we come to a question to Mr. Varshney then. When we talk about the entire concept, there's a lot of subjectivity, okay? We talked about the, operations, the control, the timing of it. Do you think, since you have been looking at policies, do you think that it would have been a better proposition had there been a specific definition that could have been included, either in the, say, model commentaries, because when you look at Article 3.2, it refers to the domestic law meaning. Do you think it would have been a better approach to address this entire issue?
Yeah, thank you. Thank you, Nabin. Basically, before answering your question, let me give my personal view, not the view of the Income Tax Department. But, I'm trying to give you a perspective as I understand when I read beneficial ownership as an academician. So basically, I feel, it's my, again, personal view, that we all, whether on the revenue side or on the tax practitioner side, we confuse beneficial ownership with anti-abuse rule. Beneficial ownership is only limited anti-avoidance rule. The larger anti-avoidance rule is contained in Article 1, where there is no PPT, and if there is a PPT in Article 29, paragraph 9, then it is contained in PPT. That limited beneficial ownership concept which is contained is often get confused. You know, when you read case law, you see everybody is going from beneficial ownership to this direction, coming back without any demarcation. And I will explain why I am saying so. Now, first of all, beneficial ownership in income tax for DTA is different to beneficial ownership as is understood in FATF or Trust Act. Just to illustrate, if a company receives a dividend, can we say it is a dividend beneficial owners are shareholders, so it should be taxed in the hand of shareholder? No, because in Income Tax Act, beneficial ownership has a limited concept. In FATF, maybe the shareholders are beneficial owners, but unless the company is a conduit company, we will tax it in company's hand only. Similarly, trust. Let's say there is a discretionary trust, private discretionary trust. Do we say that it is to be taxed in the hand of beneficiary? No, we tax it in the hand of the trust, right? But under FATF, beneficiaries are actual beneficiaries in the trust deed. So, you know, we should understand the difference between the two. And basically, this beneficial ownership is very limited concept which normally applies from income tax perspective, DTA perspective, it applies to only nominees, conduit companies and agent. So basically, whether I am receiving this income for myself or somebody else, like it has been correctly, some of the examples have been given by Dali, and I completely agree with that. Those are the fact pattern which will determine whether I am receiving it for myself or somebody else. Now the question is, how can this be different for different article of the treaty? How can you say I am an agent, I am receiving dividend income for the principal, but capital gain is mine? You know, so all this confusion is coming because of the, mixing up the two issue of beneficial ownership and anti-abuse rule. Like what happened in Blackstone. Blackstone actually was a case where 148 was issued and High Court tested that whether there was sufficient ground to issue 148. It arrived at a conclusion, and I agree with that conclusion that there were not sufficient grounds. There were absolutely no need for revenue to contend that, this Blackstone is not a beneficial owner, and there was no need for High Court to adjudicate on that point. Because OECD commentary clearly says that common investment vehicles are are the beneficial owners and not the person whose money they are holding. So just like I gave the example of trust and companies, same are CIVs. So there is absolutely no issue to even consider that point. Once again, we come to the same issue which was discussed yesterday. I don't know whether that is true or not. It was said yesterday that decisions are taken first, then justifications are given. So maybe the Blackstone, that 148 was wrong. That probably was the correct decision. And then a justification was given that, beneficial ownership does not apply to Article 13, which in my view, personal view, is completely wrong. So basically, this is the point I was trying to make. And even in Vodafone case, Supreme Court said that you may have circular number 789. So what does it mean, circular number 789? It says that beneficial ownership is proved. Fine. So that means if you are a Mauritius person, you receive a dividend income, you come forward and show me the TRC, I am an assessing officer, my hand is tied. My hand is tied only for the purpose of beneficial ownership. But if I want to apply anti-abuse rule, my hands are not tied. You know, whether PPT rule or Article 1 anti-abuse rule, and that is what Supreme Court said clearly, that assessing officer can go beyond and establish. Even in Blackstone, High Court said that there was, revenue has not proved that control and management is with the US company. That if you see, all these judgment, ultimately, the point that I am making will become clear that let beneficial ownership concept be different, let it not confuse with anti-abuse rule. Anti-abuse rule is a much wider anti-abuse rule. Beneficial ownership is a very narrow from income tax perspective, who all are covered. Probably only nominees, agent and conduit companies are covered there. So one should not try to, go beyond that concept. If one wants to go beyond, invoke PPT or where there is no PPT, Article 1 of GAR. So coming to your question that why can't we define beneficial ownership? Now there is another elephant in the room is Article 3.2. Once again, somehow I don't agree with that New Sky satellite decision that Article 3.2 should be seen at the time, domestic law definition should be seen at the time that TTA was signed. I think I covered that yesterday. I don't want to spend time, there is limited time. OECD commentary is clear that Article 3.2 has ambulatory approach. Whether you see 2010 commentary or you see 2017 commentary, it's an ambulatory approach. It probably needs to be seen at the time of application of the treaty. That is what OECD says, and that is what we feel, and we hope that this issue will get, addressed in Supreme Court. So the issue is, if revenue defines beneficial ownership today, so all of you will come and to the court and say it will apply only prospectively, it will not apply. It will not, in fact, it will not apply to any treaty, because all the treaties were signed before this law was amended. So where is the occasion to include the definition?
No, I fully agree with that, because it's so subjective, it may not be a very good idea that way. But Ajay, coming to you, I think Varshney Sahab talked about the fact that beneficial ownership is a narrow concept, and let it remain where it is. Let's not try and see that whether it gets into a PPT sort of a model or a larger anti-abuse concept. So what would be your view that is it possible for, because there are certain rulings both in India as well as outside of India, where we talk about that wherever it is not being used, that particular term not being used in the treaty, can you actually read that term into other clauses also? Be it, say, a capital gain, be it any other clause of the treaty where the term was not used. Having very well, knowing that if that was the intention, it could have been included. The treaty models have been changing after every 3-4 years. So that could have been done that way. Do you think that it could actually be read into it for other articles of the treaty?
So, Naveen, in parts you have already answered that question, that if it is not included, why do we need to really read in between the lines? And I think, I'm too small a person to really comment about the judgment which has already come in this context, whether it is Delhi High Court or it is Mumbai Tribunal. Both in the case of Blackstone, thankfully, both the judgments have set the direction on the beneficial ownership correct. They have upheld most of the international jurisprudence on this subject. They have looked at the matter very carefully, examined the fact pattern. Based on the documentary evidence, agreements, everything in place, they have judged that beneficial ownership should not be read in the capital gains article, insofar as the beneficial ownership terminology is missing in that article. Now, and I would agree with sir that, is that the only test we need to apply when you look at, international capital movement for limited capital gain purposes? That's the first stage in my view, that whether capital gain benefit is available to you or not. But the access to the treaty, whether you will pass the test of PPT, is another test which you need to satisfy and justify. Likewise, many of the treaties, you talk about Mauritius, you talk about Singapore, many of those treaties have introduced LOB provisions as well. So I can't just really say that, okay, since beneficial ownership provisions are not there, insofar as capital gains is concerned, I should be given the benefit. I have to pass the test of PPT. I have to pass the test of LOB. And then, I have to read that along with GAR, particularly after 2017, whether I will be able to really cross all these hurdles in order for me to really enjoy the benefit of beneficial ownership provision not being there. Also, while the beneficial ownership concept has not been defined under the Act, can we really read it in section, let's say 60 to 64, clubbing of provisions, what it is? That income is been handed over to some relative of a family member. Eventually it is getting taxed in the hands of the person who ought to have paid tax. It's a very, very small example in the context of beneficial ownership, but in parts it is already there in the Act. Somebody wants to invoke, they can perhaps invoke that, and wants to understand the subject, they can understand the subject. In the context of international tax practice, how major economies are looking at beneficial ownership. Very recently, from the HMRC perspective, they have introduced a concept called international movement of capital. What it means? Very simple. You need to inform HMRC how your capital is moving all over the world on an annual basis. It's a very exhaustive provision. It's a very exhaustive declaration and disclosure one has to make. It could be a good starting point. While we speak a lot about, tax fairness, I think tax governance is also going to play a very, very critical role. Again, coming back to Sir's point that what is right, can you really pass the smell test? And if you cannot, how are you going to judge yourself from the corporate tax governance point of view as well, is also a very, very big question which all of us needs to answer.
I think you rightly pointed out that yes, it has been there in the domestic law in some form or the other, but there have been a specific provision for clubbing and things like that. So that makes sense. Okay, but if I were to just flip this question for you, Aakash, why do you think, when the drafting of these model conventions were being done, why do you think that only primarily these four clauses actually have this term beneficial ownership? What was the reason behind it?
So, Nabin, that's a very interesting question that when the amendment was made in 1977, why it was restricted to the passive income, which is primarily Article 10, 11, and 12 in relation to dividend, interest, royalty, and FTS. Now, if you look at paragraph 1 of Article 10, and if we look at how that has to be interpreted, the words which are used there are paid. So if I have to see that the beneficial provisions of Article 10, paragraph 1, have to be read with respect to only the recipient of the income or the pay without reading the beneficial provision, then it may throw very absurd results. For instance, let's assume if the recipient or the payee is a nominee or an agent, as Sir mentioned, what happens in those situations? Can we say that the beneficial provisions of a treaty can be allowed to them? So hence, one has to go back to 1977 OECD Model Tax Convention when the amendment was made, and at that point of time, paragraph 2 to Article 10 was introduced, wherein the specific words which were introduced to add and say that the recipient should be the beneficial owner. Now, these words were added primarily to clarify the meaning of the word paid under paragraph 1 of Article 10. So now, if I have to look at it in a different perspective, that today the treaty benefit cannot be merely granted on the basis of the recipient of income. It may not be with the object and intent of the treaty, and hence the beneficial provisions were introduced to say that apart from being the recipient of the income, you also need to be the beneficial owner of that income. Now, coming back to the point that why it was not taken forward to capital gains. Now, very interesting, probably anyone's guess over here, but if I look at the capital gain provisions also, the article with respect to capital gain tax, the words used over there are very different from Article 10 to 12. Now, the words which are used there are derived by, earned by, alienator, or the words which are used there are gains in the hands of an enterprise. Now, these kind of words which are used in capital gains somewhere establish the principle of beneficial owner being already imbibed in the Article 13 itself. And hence, there was no need to specifically amend Article 13 and put the words beneficial owner, which was there in the case of passive income. But having said that, Because today we have got two school of thoughts. One obviously is with respect to the fact that the beneficial owner should not be read in capital gain article. Very recently, as sir mentioned, Blackstone has laid down that principle that one has to see the legal ownership and not the beneficial ownership. But at the same time, we also have Aditya Birla Nova, the Bombay High Court ruling. So right now, the matter to my mind is sub judice before the Supreme Court, and one may need to wait for the Supreme Court to lay down some guidelines whether the beneficial owner has to be read for the capital gain provisions or not.
So I just supplement with your permission. I think some very good points made by Aakash. I agree with him, that in Article 10, 11, 12, these were added because, and when these words were added, beneficial ownership, it was said that these are clarificatory. That means that was always the intention. The treaty benefit was not intended to be given to the recipient in case of an agent or nominee or conduit companies. I also agree with him that there was no need to amend Article 13 because Article 13 says drive by. So how can you say that this capital gain, if let's say an agent is holding, shares in company X, Y, Z on my behalf, now you say that, dividend should be taxable in my hand because it is paid to a resident whose beneficial ownership is Kamlesh Varshney. But when my nominee sells the share, then it is dried by him. I mean, that will lead to absolutely absurd, inconsistent result. And I'm saying this because these points will be taken up in Supreme Court. And then one should not say that pendulum is swinging, because these are very important points. And talking about Mumbai ITAT decision, in my view, it is per incurium. We have a Bombay High Court decision before Mumbai ITAT decision, which said in Aditya Birla Nova case that the question before me is whether this Mauritius company is the beneficial owner or the parent company is the beneficial owner. And then, because that will determine where capital gain will get taxed. This is the first question determined by the Bombay High Court, and then it went on to answer that Mauritius company is only a permitted transferee, like a nominee, and therefore both legal and beneficial owners are the top company. Now, when you already have a Bombay High Court decision, in my view, Mumbai IIT decision is per incurium.
Delhi, would you want to just add anything to this?
Yes. I hate to contradict Mr. Varshney because he's got very, very thoughtful arguments. But I think we can all agree on one thing. The term beneficial ownership is not included in Article 13, UN and OECD and UN models. That's a fact. And its absence is reasoned. It's not an oversight. It's not that because they forgot to add it somehow, right? And they had ample occasions to add it if they wanted to. Articles 12A and 12B were added much later to the UN model. They came with beneficial ownership, both, right? There was a proposal in 1987 to add beneficial ownership, a beneficial ownership condition, not only to the capital gains article in the treaty, actually in the UN model, but to other articles like Article 17 on artists and sportsmen. And that was rejected. It was rejected for a reason. You can agree or disagree with the reason, but it's not an oversight. And the fact that it's not an oversight has consequences in how we look at it later, right? Why they thought that it was not a good idea to include it, while they included it in 10 to 12, right? The main reason really is the frequency that there was a thought, there was an acceptance by policymakers that interposition for the purpose of improper use of tax treaties is a much riskier occurrence with passive income due also to the frequency of the transactions. Capital gains you don't do every day. Interest maybe you pay every day, every month, every quarter, right? Dividends you may pay every year. Royalties you may pay every month, every quarter, capital gains is a much less frequent occurrence. It doesn't happen every day that you sell a stake in a subsidiary, right? And so they thought beneficial ownership is not the right concept to use to counter this type of risk. The other reason, I think it was mentioned by Aakash earlier, is the purpose of the whole OECD clarification process in the commentaries is actually to clarify the words paid to, which are used in Articles 10 to 12, but not in Article 13. Thank you.
So that's another, interesting perspective, because see, at the end of the day, this is the way law is going to evolve. Okay, so I think that's very much understandable. So I think let's move to a slightly practical side of things. Divya, you have been looking at various jurisdictions like France and Netherlands, and you have operations in all these countries. What has been your view or your experience about the way the authorities in these countries have been looking at things? Specifically the concept of beneficial ownership. We'll talk about the PPT thing subsequently because that's something which is slightly newer concept. But as far as beneficial ownership is concerned, what has been your experience there?
So, I would add one more issue to this whole mix of beneficial owners. So before we start interpreting beneficial ownership, when I started looking at various countries, I just realized that this beneficial ownership concept comes from a withholding tax provisions, right? So when we say Europe, it seems very simple, right? One word, but it has a mix of 40 plus countries. Now, there are countries like Luxembourg, UK, Switzerland, Spain, France, for that matter, who have beneficial ownership concept, and they have strong withholding tax provisions. Then you have countries like, let's say, Ireland or Greece, where they do not have beneficial ownership concept, but they have withholding tax provisions, and they rely on their own domestic general anti-avoidance rules or subject to taxation rules. And then on the extreme end of the spectrum, we have countries like Cyprus, Malta, Hungary, who do not even have withholding tax provisions. So the whole confusion is bound to happen because the underlying law where this concept is being used is not even common. So, if that was not enough, then obviously this whole debate which we had as panelists here, that what is beneficial ownership? Now that's, some countries like Netherlands and all are very clear by the jurisprudence that you analyze it through the OECD commentaries. But then you have countries like Germany where they say, forget about beneficial ownership, we believe in something, a term which is called as material nexus. It's something like, I wouldn't say quite similar, but I would say something like we have a business connection in India, when it comes to permanent establishment. So most of the countries are following different approaches. Now, adding to the mix, the confusion, is the courts. Till the era of 2000, I would say there were cases of Canada, the Provost case, Cadbury case, where the courts have taken a liberal interpretation of beneficial ownership, and they said that, okay, if you are a legal owner and you have a freedom to enjoy the income, you are a beneficial owner. But then I think over from 20s till where we stand today, there is a lot of conduit companies, shell companies being introduced by many of us as taxpayers, right? And that changed the whole dynamics. That changed how courts started looking at it. So recently, for example, there is a Supreme Court ruling in Italy, which says that when you are looking at the beneficial ownership of a holding company, don't try and get the economic activity or a legal test from the operating company. Both are different. The holding company is formed for a different purpose. So please test beneficial ownership applying the holding company test. On the contrary, there comes a France Supreme Court ruling which says that, well, legal ownership probably is not enough. Let's go and test the economic activity. Oh, just one employee? Not enough. Oh, just two directors? Not enough. So the point is, where do we stop? Because every court, being Supreme Courts, taking different interpretations. But the good thing which has happened in, I would say, from 2020 to 2023, and is a consistent approach, and maybe Dali can add, is that most of these Supreme Court rulings, whether it's Denmark, Italy, France, Luxembourg for that matter, and that addresses, Aakash, your point, on the paid to angle. They are saying, okay, if you are not a beneficial ownership, at least as a taxpayer, don't live in uncertainty. Most of the courts have consistently said that just go to the next level, see who's the real beneficial owner, apply that treaty, and get, apply the same rate or treaty, no treaty situation. So I think that's something which I see as a, next step even at the courts level. The last point which I would like to make is there's a lot of haze at the tax authorities level also when we come from the courts to the local ground level. They are confused. Obviously, there's a lot of pressure on the governments and the tax authorities to crack the conduit companies. So all this, ATAD filings which are coming, this is basically a recent introduction of law across Europe where most of the companies have to do a filing if it's like a parameter of 13, 15 substance-related criteria where you have to make a filing for them to make sure that whether you are a conduit or not. And in Europe, the law is different that they know that a taxpayer may not do these filings, so they put the burden on the intermediaries, your service providers. When you enter into engagement letter with your service provider, they ask you, are you ATAD compliance? Otherwise, they won't provide you a service. On the top of it is DSC 6 filing, which came and has been deferred across Europe, which basically says that if you are doing any big merger and acquisition transaction, then either it's your duty or it's your intermediary to answer, again, 30 questions, which basically lead to a situation that has this transaction being done with the principal motive of tax avoidance. Have you set up the companies for the reason? And then last, I would say, all of us spoke about money laundering and all, then you have all this ultimate beneficial ownership registers filing coming in. So there's a lot which is brewing up, I would say, internationally also. In the end, I would hope as a taxpayer that all of this will culminate into one pot, which is having certainty for us as a taxpayers that this is exactly what I need to see.
So I think that's something which is very important. So every country is looking at its own ways, creating more documentation requirement, filings and things like that. So I think that's something which is very interesting. And I think hopefully there would be some certainty that would come soon. So I think with that, Ajay, I just wanted to check with you, you have these transactions across borders with maybe back-to-back financing and funding and, funding and then maybe investment through equity route and things like that. So what has been your experience with the way the documentation or the paperwork that would have got modified in the last, say a decade or so? So how do you see the documentations getting changed and the way the payers are looking at or asking you questions on various transactions?
I think that's the bedrock of this entire litigation around beneficial ownership. I think Dalit talked about if you get the dividend and without even application of mine, you upstream the dividend to a holding company and then the holding company upstreams the similar dividend to the ultimate holding company, then obviously, litigation is bound to happen. So documentation plays a very, very important role. And without appropriate agreement, without safeguards, without proper consultants, it is impossible to really navigate. This area is ever evolving. If you look at the plethora of judgments which are coming, it's coming due to the fact that there is a situation where tax authorities, not only in India but globally, are trying to crack this entire chain of fund flow. They are trying to understand, are there any tax abuse or treaty shopping, which is leading to tax leakage? Perhaps these are some of the reasons why we have this Pillar 1, Pillar 2, BEPS, and basic minimum tax all over the globe. In order for you to discourage any kind of tax planning with a motive to evade taxes. Do we have back-to-back financing? Do we have investments coming from various countries to India? Absolutely, the answer is absolutely right. Do we have appropriate arrangements in place to ensure that we pass the smell test, to ensure that there is a genuine commercial rationale for us to put this transaction together and therefore should claim the tax treaty benefits. We have a case right now, I can't really speak too much about it, but we have a case currently going on in the Delhi High Court. We have filed a writ against a particular judgment and pretty much talks about the similar issue. And the hearing has happened almost 7 days straight. The judgment is yet to come. There is a likelihood that the hearing may again resume because of a variety of other reasons. But we are quite hopeful that we will be able to justify and articulate why the transaction was done the way it was done, Nabin.
So that's interesting. Divya, anything that you would want to add on the documentation, maybe the way the bankers are looking at it nowadays?
So before, the bankers, I would give my view as a taxpayer, and you asked Ajay that how the documentation has evolved. I would say that, when I look at today's documentation, I feel like a KG class student once again, because, a lot has changed on documentation. Earlier, for example, transfer pricing, let's say, I'm dealing with 15 jurisdictions. So there is a holdco and you have multiple jurisdictions. You get one transfer pricing study done. It's okay, you apply the same rate. But in a back-to-back financings, now transfer pricing plays such an important role. And then it eventually gets linked to your determination of being a pass-through entity or not, because you have to leave a particular spread in each country. You can't just have, the same rate passing over as interest. Similarly, see, there is a reason why, I would not say conduit companies, there are intermediaries being formed for commercial reasons. Let's say there is a 15 entities and then there is a holdco on the top. Now you want to bring a JV partner. What will you do if you don't have a holding company? You can't bring a JV partner into all 15 jurisdictions. They are tied on the hip with a holding company. So there are commercial reasons, but then, don't skip those commercial reasons in the documentation and just focus on tax evasion or trying to shop the treaty. I would say that, have a proper transfer pricing study done, have a proper back-to-back financings, have proper documentation which gives tax authorities also a proper view of why you have done. And that is what distinguishes the back-to-back financing in a clear tax treaty shopping case versus a real genuine commercial case. That's my experience of dealing with the authorities.
Thanks. I think let's change the track a bit. Let's look at, we talked about the history. Now let's talk about how things are going to pan out as we move forward. So, Mr. Varshney, I just wanted to check with you, India is a signatory to MLI, and PPT is something which is going to evolve as we move forward. So how do you see the interplay between, although you alluded to it earlier as well, how do you see the interplay between beneficial ownership and principal purpose test with respect to the passive income, articles, as well as the other articles for that matter?
See, I have, you correctly said that I have already, discussed this before, that beneficial ownership is a limited anti-abuse rule. The Article 1 anti-abuse rule and PPT, which is in Article 29, is much wider. So just because you are beneficial owner does not mean that revenue cannot, try to invoke PPT if it is there in the DTA. If not there, then invoke Article 1, that you are not entitled to treaty benefit because it is an abusive structure. So that, I don't think that there is too much dispute on that. I refer to Vodafone judgment also. They also clearly said that even if you are beneficial owner, assessing officer can establish it as an abusive transaction. So there, I mean, in my view, this is not something which is debatable, and probably, we all should understand that, and once again, should not mix the two. Beneficial ownership is different, and passing the principal purpose test is completely different. Both need to be satisfied, both need adequate documentation, and they have different tests for themselves. So that should be kept in mind, but somehow I only, see, I have not read that NetApp judgment which Badri was narrating yesterday. I only heard what he said. And from what he said, immediate question to my mind was that why beneficial ownership in that case? It should have been the, anti-abuse structure, that just before declaring dividend, you created a structure in a tax haven so that Cyprus, so that it does not suffer withholding tax. So I thought, those are the things probably will become more clear in future, and that they should become more clear.
Sure. No, that's something which is important. But, Aakash, I would just bring in you here, because when we are talking about this Indian context, we also have our GAR, and the GAR panel has become operational now. So do you think that there is any support or any sort of a precedence value that would come in, based on the way the GAR panel is going to come up with their observations with respect to both beneficial ownership as well as the principal purpose test?
So I think one, we need to understand and appreciate that beneficial ownership is a concept which is there under the treaty, while GAR is a concept under the domestic tax law. There are certain commonalities between the two. Now both are anti-abuse, both read the substance over form test. But at the same time, if I look at GAR, it was initially introduced in 2009 and finally got incorporated in the law in 2017. Now, it was about 8 years. The government has given enough time to the industry at large to absorb the principles of GAR and be ready to understand the principles, how they're going to apply GAR. Now, if you look at GAR, it says that the main purpose has to a tax benefit plus satisfaction of one of the tainted element test. Now, one of the tests over there, Nabin, talks about lack of commercial substance. Now, if I look at a structure, for instance, let's say there's a Singapore company which has got investments done in India. Now, the possible questions which may come is that why that structure was built from Singapore? Was there a thought and an evaluation done that if not Singapore, what are the other jurisdictions which can be selected, say Mauritius, Malaysia, or UK for that matter? At the same time, somewhere these kind of questions gives an impression that one has to look at the beneficial owner or the legal ownership as well. But if you ask me, and I agree with sir, that beneficial ownership and GAR both have to be looked separately. There are different principles when you are evaluating GAR and when you are evaluating beneficial ownership. But at the same time, it needs to be seen how the panel, the GAR panel, is going to look at beneficial ownership, and will they get into the criteria, meeting criteria for beneficial ownership when they are evaluating applicability for GAR on a particular transaction. But if you ask me, in summary, beneficial ownership probably to my mind is a narrower term, while GAR, you got several powers which are given to the department to look at the transaction from a holistic perspective.
No, that's an interesting bit. So I think before I think we end, one specific practical question, Divya. You talked about the withholding tax bit, okay? And we are sitting here in India. 195 talks about payouts and the payer being responsible to identify the income which is chargeable to tax and then do the proper withholding. And that's the genesis of the disputes around beneficial ownership. Now, what would be your view? Like, a person who's making a payment, is he supposed to, he's supposed to look at the permanent establishment part of it, the way things have evolved over a period of time. Is he also supposed to look at the beneficial ownership of that person and then decide which treaty to apply, whether treaty to be applied at all or not, and then decide the withholding tax, as far as the Indian context is concerned?
So I would say, unfortunately, that's how it is. As a payer, if I'm paying in the group, it's a dividend situation, then it's far more obvious for me to know whether my recipient is a beneficial owner or not. I may try and create provisions around the same internally, but I would know. But when it comes to the third parties, that's a different situation where I may not be knowing. The classic change which I see in today's time as a payer or from a withholding tax perspective is that the lot of documentation is undergoing a change. For example, I'll discuss a latest case which I am dealing. I'm taking a hedging of my financing, which is across 15 jurisdictions from an Indian bank. Now, when the Indian bank papers arrived at my desk, I saw, it's not the classic old documentation where they're saying that, and it's, let's say my primary obligor is from Luxembourg. If I go back, rewind 4 years ago, the documents used to say that the recipient of income is a tax resident of Luxembourg. Matter ends. But today, when the tax representations in that agreement comes to me, they have all the clauses on the beneficial ownership. They have all the clauses of the primary test under the tax reps, which shows that as a payer, how people are trying to assess and determine through documentation instead of a side letter which we initially used to take on the permanent establishment. The trend is changing to include it in the warranties in the agreement, which means that if I'm breaching a rep or a warranty, then a side letter, I have contractually far more different repercussions than, having just a side letter. So that's where the changes are occurring.
So I think that's something which is changing, and I think that is something which is going to create an onus on the payer as well. Yeah, Dali, you wanted to add something?
Yeah, if I could add a word on this. So in comparative practices between countries, like DVS says, generally, you are doing work for the government, but you bear the risk. You are collecting money for the government, but if you do it wrong, you have a problem. In Germany, for example, now this is following something which is called the CumEx scandal. It's a huge scandal about claiming multiple withholding taxes in Germany. What they did is that in order for the paying agent or the withholding agent to apply the treaty benefit on payment and not by way of post-facto fund, you need first to apply to the tax office and obtain a green light. They call it certificate of exemption, right? And that limits the risk, right? Because if the tax office already gives you a certificate, it means that they went through the papers and they determined that you are entitled to that. Of course, it has downside because then it takes more time, more paper, more things, et cetera, et cetera.
Sure. Thank you. Thank you. I think before we end, I think last question to Mr. Varshney. Sir, we have so many companies operating from India, paying out various dividends, royalties, and we talk about India being the next China, okay? We are looking at some of the manufacturing that are coming in here. We are trying to make ourselves as a manufacturing hub, maybe creating a substitute. So your suggestion or your guidance to the taxpayers, who are operating in India, because you have a lot of view from the departmental side as well.
Simple, short. I see everyone standing there. We have overshot our time. India will be India, not China. That is one thing. And secondly, I have said it before, don't mix the two. Beneficial ownership is different. Principal purpose test is different. Do your documentation for both. Proper documentation, and why abuse, why go for tax abuse? Just pay your tax honestly. Thank you.
Thank you, sir. Thank you very much. I think that's something which is interesting. So I think with that, we will end this panel. I can see Arun just, chasing us. So I think we'll thank you all of you. It was really interesting. It's going to evolve over a period of time.
Very, very interesting session, Nabin. Thanks so much. A big hand for the panelists. Can you please pose for a photograph so that we can... Thanks. We'll start the next session, the highly anticipated session, Fireside Chat with Lakshmi Kumaran sir, moderated by acclaimed financial journalist Govind Ethiraj, who's